Avoid legal mistakes when buying property in Cyprus. The biggest risks when buying property in Cyprus are rarely the ones you see in the listing or the ones the estate agent will disclose. The real risks are hidden in the legal and technical status of the property, mortgages you didn't know existed, permits that were never issued, title deeds that cannot be transferred or cannot be issued, clauses that quietly shift liability to you, or deposits that become non-refundable the moment something goes wrong. A property can look perfect, the seller can look trustworthy, the agent can sound confident, and yet the transaction can still be legally unsafe if the right checks are not done in the right order. In this video, I will break down the most common hidden legal risks we see when international clients buy property in Cyprus and exactly how to avoid each one. At Philippou Law Firm, we advise local and international clients on Cyprus property transactions from start to finish, due diligence, contract negotiation, VAT and cost planning, title transfer and legal protection throughout. If you remember only one thing from this video is do not pay anything to anyone before the property paperwork is legally reviewed. Most problems happen because buyers follow the wrong sequence. They pay first, sign quickly, and only afterwards ask for legal review. The correct sequence, however, is always the following: legal checks first, protective contract second, payment structured third. That sequence alone prevents a huge percentage of the problems buyers face later. Let's look at the risks. Risk number one: you may not be buying from the real legal owner. This sounds basic, but it's a real issue. The person selling may not be the registered owner. The property may be jointly owned without all the owners agreeing. The seller may be a company whose signatory has no authority, or the title deed may still be in the name of a developer, even though the property is marketed as a resale. If you sign or pay before ownership is verified, you can end up in dispute that takes months or years to resolve. Before signing, your lawyer should verify who the registered owner is at the land registry, whether co-owners exist and consents are needed, whether a company seller has proper authority and legal capacity to sell, and whether the property matches the legal description, including the unit number, the plot reference, parking, storage, and any appurtenant rights. If something is not ready yet, vague assurances are not enough. The contract must protect your rights. Risk number two: mortgages, memos, charges, and other encumbrances. A property can be burdened by a bank mortgage over the land, a court memo, a charge in favor of a third party, or a restriction that blocks transfer. Many buyers are told, "Don't worry, the developer will clear it. This is normal process in Cyprus." But normal is not the same as safe. If there is a mortgage over the land with no proper release mechanism, you can pay for the property and still never receive the title deeds later on. You need two things. First, an official land registry search before you sign the contract. Second, contract terms that require written bank confirmation of release upon a specific payment, a clear release procedure, payments structured around that release, seller obligations to transfer the title deed free of encumbrances, and remedies if they fail, such as retention, repayment protection, or other contractual consequences. If a seller refuses to discuss encumbrances transparently, that is a red flag. Risk number three: you sign a contract, but still your rights are not properly secured by that contract. A contract of purchase is important, but what happens immediately after signing matters just as much. In Cyprus, one of the key protections available to buyers is the proper lodging of the contract of sale at the land registry office under the specific performance framework. If the contract is not lodged, the buyer's rights are personal rights against the seller only, not secured against the property or third parties. If the seller later creates new encumbrances, faces creditor issues, or attempts to deal with the property in a way that overrides the buyer, the protection is significantly weaker than believed. Your lawyer should ensure that the contract is in a form that can be properly lodged, and that formalities are handled correctly, and that lodging happens on time. A contract which exists but is not lodged means the buyer is not actually secured. Risk number 4: paying the reservation deposit without receiving the proper receipt. The agent says, Pay 5,000 euros or 10,000 euros now to reserve the property. There are other viewings. You may lose this property of your dreams. Buyers panic and pay without reviewing the document they're signing. Many reservation forms protect the seller, not the buyer. They may say that the deposit is non-refundable, they don't explain what happens if legal issues arise, do not state where the money will be held, and do not make the reservation conditional on due diligence. A proper reservation form or agreement must clearly state under what conditions the reservation deposit is being paid, when it is refundable, where the money will be held, and how long the property stays off the market while legal checks and due diligence are carried out over the property. If someone pressures you to pay immediately or lose the property, treat that as a warning sign, not a reason to rush. Risk number 5. Construction permits are missing and title deeds cannot be transferred. Very usually we hear things like title deeds will be ready later is one of the most misunderstood phrases in Cyprus property. Sometimes that's normal, sometimes it's a warning sign. There are reasons why title deeds may not exist for a property, and these include ordinary administrative delays, missing planning or building permits, lack of final approval certificates, encumbrances on the land, developer insolvency, or project disputes. This is especially common with properties that have extensions, converted verandas, roof terraces, basement conversions, or internal changes where the as-built reality does not match the approved plans, causing title deed delays, financing problems, resale issues, or regulatory exposure. Your legal review must verify whether correct planning and building permits exist, whether there is a final approval certificate, whether the actual property corresponds to the approved plans, and what the realistic timeline for title deed issuance is. Where the property does not match the plans, the question is whether there's a legal path to legalize it. If the seller needs to legalize an issue before the transfer, that must be a contractual obligation with clear timing. If the buyer is knowingly accepting an irregularity, it must be disclosed, priced, and understood, not discovered later on. Risk number 6. You plan to rent the property, but you do not check for any restrictions. Many buyers assume that they can use a property however they want once they buy it. Restrictions can arise through building management rules, project-specific restrictions, or developer contracts. Discovering a short-term rental restriction after purchase can fundamentally change the investment case, especially if rental yield was a core part of the buying decision. Before you buy, confirm what rules may apply for the building, whether short-term rentals are restricted, what communal obligations exist, and whether there are pending disputes affecting intended use. The contract should not quietly restrict your use without you realizing it. Risk 7. You ignore common expenses, management and building liabilities. In apartments and complexes, the risk is not just the unit, it's the whole ecosystem. High common expenses, poor management, sinking funds, unpaid communal bills, or disputes between owners and developers. Ask to see the management rules and the fee structure, typical annual common expenses, whether communal obligations will be cleared before completion, and whether there are known disputes affecting the building. This is especially important for investment buyers who need accurate annual cost forecasting. Risk number 8. You do not understand the real costs, so you budget wrongly. A purchase includes more than the price. Budget for VAT, transfer fees, bank due diligence charges, handover costs, insurance, communal fees, and legal fees. The risk is assuming the wrong tax treatment or ignoring the total cost profile until it's too late. Whether VAT applies, whether transfer fees apply, and how they're calculated depends on the nature of the transaction and must be assessed before signing the contract, not after. Risk 9. The contract is standard, but it actually protects the seller. Many buyers are told that all contracts are standard and legal review is unnecessary. That is one of the most expensive assumptions in Cyprus property transactions. A standard developer contract often includes delivery delays with no real remedies, penalties that apply only to the buyer, broad rights to change specifications, weak snagging obligations, and risk transfer to the buyer too early. A buyer protective contract needs to have clear construction and delivery provisions, a snagging process and defect liability periods, Payment milestones linked to evidence and progress of construction works. Consequences for delay, clear encumbrance release language, and proper obligations around title deed issuance. The contract is not a formality, it's your protection document. Risk number 10. Non-EU buyers forget that there is a permission process necessary. Non-EU buyers can purchase property in Cyprus, but additional procedural requirements apply in many cases. Cyprus provides an official application process for non-EU purchasers seeking consent to acquire immovable property. If that timing is not factored in from the start, completion of the property purchase can stall, particularly if permission has not been obtained before the agreed transfer date. This can often delay financing release, affect immigration planning, or put the transaction at risk. From the start, know whether permission is required, what the timing implications are, and how to align the purchase with any other wider immigration planning. Risk 11. Access, right of way, and legal reality do not match the marketing of the property. This category causes disputes years later. No legal access, rights of way across the property, boundary inconsistencies, parts of the garden not included in the title, or easements affecting future use. These issues are invisible in a property viewing, but can prevent renovation, restrict future development, or create neighbour disputes. Property due diligence should include checking plans and boundaries, confirming access and easements or servitudes, and verifying parking, storage, or exclusive use rights being marketed as part of the property, especially if you intend to renovate, extend, or resell later on. A proper legal process includes ownership and encumbrance checks, title deed and transfer feasibility review, permit and planning review where relevant, buyer protective contract drafting and negotiation, payment structuring linked to legal milestones, proper post-signing steps including lodging, and clean completion and transfer planning. That is how you buy property in Cyprus with confidence and without avoidable surprises. A safe purchase is not about being paranoid, it's about being structured. If you're buying property in Cyprus as a home, an investment, or part of a relocation plan, do not treat it as a quick transaction. Most legal problems are preventable, but only if the right things are checked before you commit. Speak with our team at Philippou Law. We will tell you what actually matters, what needs to be fixed, and how to move forward with proper legal protection from start to finish.